Assalamu alaikum wa rahmatullahi wa barakatuh. May peace be upon you. I'm here to show you what the Supreme Court have ruled for the driver's license here, and it clearly states that U.S. Supreme Court and other high court citations proven that no license is necessary for normal use of an automobile on common ways. And it also states may be permitted or prohibited at will, but a common right which he has under his right to life, liberty, and the pursuit of happiness. Under the constitutional guarantee, one may, therefore, under normal travel at his inclination along the public highways or in public places, and while conducting himself in an orderly and decent manner, neither interfering with nor disturbing another's rights, he will be protected not only in his person but in his safe conduct. Thompson versus Smith, 154 SE 579, 11 American Jurisprudence, Constitutional Law, Section 329, page 1135. The right of the citizen to travel upon the public highways and to transport his property thereon in the ordinary course of life and business. It is a common right which he has under the right to enjoy life and liberty, to acquire and possess property, and to pursue happiness and safety. It includes the right, in so doing, to use the ordinary and usual conveyances of the day, and under the existing modes of travel, includes the right to drive a horse, drawn carriage, or wagon thereon, or to operate an automobile thereon, for the use and ordinary purpose of life and business. Thompson versus Smith, Supra. Tetchy Lines versus Danforth, Mississippi, 12S2D 784. The right of the citizen to drive on a public street with freedom from police interference is a fundamental constitutional right. White, 97 Cal. App. 3D. 149, 158. Cal. RPTR. 562, 566-67, 1979. Citizens have the right to drive on the public street of the District of Columbia or any other city absent a constitutionally sound reason for limiting their access. Kenesha Mills versus DC 2009. The use of automobile as a necessary adjunct to the earning of a livelihood in modern life require us, in the interest of realism, to conclude that the right to use an automobile on the public highways partake of the nature of a liberty within the right to operate the right to operate a motor vehicle an automobile upon the public streets and highways is not a mere privilege. It is a right of liberty, the enjoyment of which is protected by the guarantee of the federal and state constitution. Adam versus City of Pocatello, 416 P2D 46, 48, I guess 91, Idaho 99, 1966. A traveler has an equal right to employ an automobile as a means of transportation and to occupy the public highways with other vehicles in common use. Campbell versus Walker, 78, Atlanta 601, 603, 2, Boyce, Delaware, I guess, 41, period. The owner of an automobile has the same right as the owner of other vehicles to use the highways. A traveler on foot has the same right to use of the public highways as an automobile or any other vehicle. Simon versus Lindsay, 65, Atlanta 778, 779, Hannington versus Wright, 63, Atlanta 234, 236. The right of the citizen to drive on the public street with freedom from police interference unless he is engaged in suspicious conduct associated in some manner with criminality is a fundamental constitutional right which must be protected by the courts. People versus Horton, 14 Cal. App 3/3, 667, 1971. The right to make a use of an automobile as a vehicle of travel along the highways of the state is no longer an open question. The owner thereof have the same rights in the roads and streets as the drivers of a horse or those riding a bicycle or traveling in some other vehicles. House versus Kramer, 112 Northwest 3, 134 Iowa 374. Farnsworth versus Tampa Electric Company, 57 So, point 233, 237, 62, Florida, I guess, 166. The automobile may be used with safety to others users of the highway, and in its proper use upon the highways there is an equal right with the users of other vehicles. Okay. Okay, the law does not denounce motor carriages as such on public ways. They have an equal right with other vehicles in common use to occupy the streets and the roads. It is improper to say that the driver of the horse has the rights in the roads superior to the driver of the automobile. Both have the right to use easement. Indiana Spring Company versus Brown, 165 Indiana 465, 468. I guess those are pages or something. A highway is a public way open and free to anyone who has occasion to pass along it on foot or with any kind of vehicle. Schillinger versus City of Atlanta, 129 Southeast 861, 871. I guess those are pages. 161 Georgia, 148, 159, Holland versus Shackelford, 137 Southeast 2D 298, 304, 220 Georgia 104, Stavala versus Palmer 73, 73 A2D 831, 838, 136 Connecticut, I guess, 670. There can be no question of a right of an automobile owners to occupy and use the public streets of cities or highways in a rural districts. Libridge versus Crandall, 126 Northwest 69, 110 Minnesota 454, 456. I guess those are pages. The word automobile connotes a pleasure vehicle designed for transportation of persons on highways. American Mutual Liability Insurance Company versus Chaput 68 2D 118, 120 95 NH 200 motor vehicles. 18 U.S.C. Part 1, Chapter 2, Section 31, definitions. 6. Motor vehicle. The term motor vehicle means every description of carriage or other contrivance propelled or drawn by a mechanical power and used for commercial purposes on the highway. 10. The term used for commercial purposes means that the carriage of a person or property for any fare, fee, rate, charge, or other consideration, or directly or indirectly in connection with any business or other undertaking intended for profit. A motor vehicle or an automobile for hire is a motor vehicle, other than an automobile stage used for only to local regulations, only to local regulation, i.e., safety, caution, traffic lights, speed limits, etc., period. Travel is not a privilege requiring licensing, vehicle registration, or forced insurance, period. Chicago, Coach Company versus City of Chicago. Let me repeat that. Only to local regulations, i.e. safety, caution, traffic lights, speed limits, etc. Travel is not a privilege requiring licensing, vehicle registration, or forced insurance. Chicago, Coach Company versus City of Chicago. 337, number 3, 200, number 3, suite 200, 169 Northeast 22. Traffic infractions are not you ready? A crime. Let me repeat that. Traffic infractions are not a crime. People versus Battle. Persons faced with an unconstitutional licensing law which purports to require a license as a prerequisite to exercise of right. Let me repeat that. People versus Battle. Persons faced with an unconstitutional licensing law which purports to require a license as a prerequisite to exercise of a right may ignore the law, and engage with impunity in exercise of such right. Shuttlesworth versus Birmingham, 394. U.S. United States 147, 1969, U.S. Supreme Court says no license necessary to drive an automobile. You want me to repeat that? I guess you got the point. On public highway streets, no license is necessary. Copy and share freely, please. YHVH, I guess that's in the First Testament. Name 3, the word operator. Shall not include any person who is solely transports his own property and who transports no persons or property for hire or compensation. Statutes at Large, California, Chapter 412, page 83. Highways are for the use of traveling public, comma, and all have the right to use them in a reasonable and proper manner. The use thereof is an inalienable right of every citizen. It's an inalienable right of every citizen. Escobedo versus State, 35 C2D 870 in 8 Cal. Jury, 3D P27, right. A legal right, a constitutional right, means a right protected by the law, by the Constitution, by government, does not create the idea of right or original rights. It acknowledges them. Bovier's Law Dictionary, are you ready? 1914, page 2961, period. Those who have the right to do something cannot be licensed for what they already have right to do. As such, license would be meaningless. Do you hear me? Are you ready? Okay. City of Chicago versus Collins, 51 Northeast 907, 910, period. A license means leave to do a thing which the licensor could prevent. Blatz Brewing Company versus Collins, 160, page 2D, I guess P2D 37, 39, 69 Cal, point A, Cal point A, point 8, period, I guess, 2D 639. I'm going to call her a point, okay? Period. The object of a license is to confer a right or power which is immoral. It's not moral to have a license. It's immoral, which does not exist without it. Payne versus, you ready? Massey, 19, they don't know what year it is. 196 Southwest 2nd, 493, 145. I guess Texas 273, period. The court makes it clear that a license relates to qualifications to engage in profession, business, trade, or calling. Thus, when merely traveling without compensation or profit outside of a business, enterprise, or adventure with the corporate state, no license is required of the natural individuals. May I add the S apostrophe S, please? Traveling for a personal business, pleasure, and transportation. Winfield versus Fielders, 2D, California, I guess 3D 213, 1972. If state officials construe a vague statute unconstitutionally, the citizen may take them at their word and act on the assumption that the statute is void. Let me repeat that. If state officials construe a vague statute unconstitutionally, the citizen may take them at their word and act on the assumption that the statute is void. Do you hear me? Let me hear you say, hey. Okay. The term motor vehicle is a different and a broader than the word automobile. City of Dayton versus DeBrasi, 23 Northeast, I guess, 2D, 647, comma, 650, and comma, I guess, 62, Ohio, APP dot 232. Thus, self-driven vehicles are classified according to the use to which they are put, rather than according to the means by which they are propelled. Ex parte Hoffert, comma 148, Northwest 20. The Supreme Court in Arthur versus Morgan, 112 U.S. 495 5S, I guess court, period 241, comma 28 LED 825, comma held that carriages were properly classified as household effects. Let me repeat that. Held that the Supreme Court, Arthur versus Morgan says, okay, held the carriages were properly classified as household effects, and we see no reason that automobiles should not be similarly disposed of. Hill House versus United States, 152F, 163, 164. Second Circle, 1907. A citizen has the right to travel upon the public highways and to transport his property thereon. State versus Johnson, 243, page 1073. Commons versus Holmes, 155, p. 171, page 171. Peckett versus Banton, 44, South Court, 256. Hadfield versus Linden, 98, Washington 516, comma Willis versus Buck, 263, p. 1982. Barney versus Board of Railroad Commissioners, 17P 2D82. The use of the highways for the purpose of travel and transportation is not a mere privilege, but a common and fundamental right of which the public and the individual cannot be rightfully deprived. Chicago Motor Coach versus Chicago, 169 Northeast 22, Lingair versus Chicago, comma 28 Northeast, 934. Boone versus Clark, 214 SSW, 607, comma 25 AM, I guess period jur period first highway, section 163. The right of the citizen to travel upon the highway and to transport his property thereon in the ordinary course of life and business is the usual and ordinary right of the citizen, a right common to all. Ex parte Dickey versus Davis, 85 Southeast 781. Every citizen has an unalienable right to make use of a public highway of the state. Every citizen has full freedom to travel from place to place in the enjoyment of life and liberty. People versus Nothis, 147 Colo, I guess Colorado. 210. No, okay, you guys ready for this? Pay attention to this part now. No state government entity has the power No state government entity has the power to be overthrown or impaired by any state police authority. Okay? No, you want me to repeat that? Let me repeat that for you. No state government entity at the bottom page now. No state government entity has the power to be overthrown or impaired by any state police authority. Donnelly versus Union Sewer Pipe Company, 184 U.S. 540. La Ferrers versus Grand Trunk R&R Company, 24A 848. O'Neill versus Providence Amusement Company, 108A 887. The right to travel, called the right to free, you ready? Ingress to other states. An ingress from them is so fundamental that it appears in, are you ready? Are you ready? That it appears in the Article of Confederation. Holy God! Which governs our society before the Constitution. Paul versus Virginia. The right to travel freely from state to state is a right broadly assertable against private interference, as well as government action, like the right of association. It is virtually unconditional personal right guaranteed by the Constitution to us all. U.S. Supreme Court, Shapiro versus Thompson. Edgerton, Chief Judge. Iron curtains has no place in a free world. Holy God. Chief Judge Edgerton, Chief Judge. Let me repeat that for you. Iron curtains have no place in a free world. Undoubtedly, the right of locomotion, the right to remove from one place to another according to inclination, is an attribute of personal liberty and the right ordinarily of free transit from or through the territory of any state. Let me repeat that. An attribute of personal liberty and the right ordinarily of a free transit from or through the territory of any state is a right secured by the Constitution. William versus Fears, 179 U.S. 270, 274, 21 South Court, 128, 45 LED, 186. Our nation hath thrived on the principle that outside areas of plainly harmful conduct, every American is left to shape his own life as he thinks best, do what he pleases, go where he pleases. ID at 197, Kent versus Dulles, C. Vestal, freedom of movement, 41 Iowa, L. Reverend 613-14. The validity of restrictions on the freedom of movement of particular individuals, both substantively, I can't pronounce that, both substantively and procedurally is precisely the sort of matter that is peculiar domain of the courts. Comment. 61 Yale LJ at page 187. A person detained for an investigatory stop can be questioned but is not obliged to answer. Answers may not be compelled. That means it's not forced. And refusal to answer furnishes no basis for an arrest. A cop can't arrest you for driving cars or not answering questions. It's against your constitutional right, people. Justice White Table automobile have the right to use the highways of the state on an equal footing with the other vehicles. Cumberland Telephone and Telegraph Company versus Yeaser. 141 Kentucky 15. Each citizen has the absolute right to choose for himself. Pay attention. To choose for himself the mode of conveyances he desires, whether it'll be a wagon or carriage, by horse, motor, or electric car, or by bicycle, or astride of a horse, subject to the sole condition that he will observe all those requirements that are known as the law of the road. Swift versus City of Topeka. 43 U.S. Supreme Court says no license. And we are at, I believe, the last page, y'all. Hang on with me here. U.S. versus Mirsky, 1960, 361, U.S. 41. An administrative regulations, of course, is not a statute. Okay? U.S. versus Mirsky, U.S. 431. An administrative regulations, of course, is not a statute. A travel on foot has the same right to use of public highways as an automobile or any other vehicles. I guess Ketchy versus Lindsay. 75 Atlanta, 376, 377, 1 Boise, Delaware, I guess. 185. Period. Automotive vehicles are lawful means of conveyances and have an equal rights upon the streets with horses and carriages. Chicago Coach versus Chicago Company